Hello, my name is Brant Hunt. My channel is Discerning What is True. I am actually on Facebook Live now. I'm also on Odyssey and YouTube. And if you see me, it'll be under my name. And Facebook will be Brant, B-R-A-N-T, last name being Hunt, H-U-N-T. And what we're going to be doing is going through this particular book here by Eustace Mullins, The Rape of Justice. So we're going to try to go through maybe a chapter tonight and discover some important issues. And I'm hoping everyone is doing well. It's been a somewhat warm day here in the southern South in the United States, being probably in the mid 70s, and got a chance to spend some time not only at work today, but also got to visit to ducks and got to take some beautiful pictures tonight of the moon and the sun going down, which is always impressive. So let's get into the book here by Eustace Mullins. Eustace Mullins is I'll tell you a little about him as we go through his background. This is a particular book is the Legal Studies Group of the National Commission for Judicial Reform presents the latest investigative research coup of Eustace Mullins in the hopes that it will aid the citizens of America to reduce the odds against winning a favorable decision in our courts. A native Virginian, Eustace Mullins is a descendant of William Mullins, whose name is on the Mayflower Compact, a government code written for the Mayflower settlers and the first compact written in the New World. He served 38 months, that is, Eustace Mullins served 38 months in the United States Army Air Force during World War II. He was educated at Washington Lee University, also at Ohio State University, University of North Dakota, and at New York University. And actually, he was also involved in the Institute of Contemporary Arts in Washington, D.C. His name, Eustace, means justice in Aramaic, the language spoken by Jesus Christ. In his 40 years of investigative work, Eustace Mullins' rapid progress was made possible by his becoming the protege of Ezra Pound, the leading literary force of the 20th century. No one even knows who this guy is, folks, but he was a brilliant man. And the reason why was shunned is because he spoke out against his government here in the United States. And they chose to throw him in a mental institution in Washington, D.C. So much for freedom, folks, even back in the 1940s and 30s. George Stimson, founder of the National Press Club and the most respected journalist in Washington, D.C., and then also with H.L. Hunt, the business entrepreneur with a consuming interest in good government. After Ezra Pound's passing, Eustace Mullins founded the Ezra Pound Institute of Civilization, which carries on Pound's groundbreaking work in literature and economics. So the first chapter he'll be contending with here is Eustace will be called Legal Authority. Legal Anarchy. Legal Anarchy. Here's the forward of it. In my travels throughout the United States, I have found that the first complaint of any citizens in this country is the sorry state of our legal system. They do not complain that the laws themselves are odious, but rather that their administration is almost universally unfair and unjustified. I even heard farmers arguing each other at their markets, each protesting with inverted pride that our country has the crookedest lawyers and judges in the state, only to be met with the fervent response from a farmer representing another country, or another county, I should say. Oh, no, our lawyers and judges are a lot crookeder than the ones in your county. So Americans recognize that we must have laws and that we must abide by them. Otherwise, life would become intolerable. The problem is that law-abiding citizens are usually greeted in our courts with disbelief that anyone still obeys the laws of this nation, and two, that a legal system which is operating by and for criminals has no greater enemy than the law-abiding citizen. The first purpose of law has always been salutis populorum, meaning the safety of the people. I write this in a building which has 5 locks on every door. 25 years ago, the doors were never locked. We hardly knew where the key to the front door was kept, with hundreds of other citizens in Washington during its tropical summers. I went to a nearby park to sleep in the air before air conditioning. Today, no one in his right mind would close his eyes in Washington Park, either by day or by night. It is rightfully known as a murder capital of the world, rather than as the capital city of the United States of America. This situation has been created not by the negligence of the police, who are working harder than ever, but by the legal system, which abruptly denied the previous basis of our legal system. Salutis Publier in 1933, with the advent of President Franklin Delano Roosevelt, who adopted the Marxist concept that the legal system was being used unfairly to defend property. Because of the communists' agreed that all property was now the property of the state, the legal system needs no longer defend crimes against personal property. This was soon extended to crimes against persons. A doctrine of compulsory equality meant that no citizen was entitled to wear a gold watch or to live in a large home. Other citizens who wished to deprive them of their excessive property, even at the cost of their lives, were looked upon with approval by the legal system. If they injured or killed too many citizens in their exuberance, they might be confined for a short time, but they were soon released to continue the Marxist campaign of leveling, that is, of reducing all citizens to a common level of fear and despair. This goal was first achieved in the Soviet Union when Wall Street bankers financed the noble experiment in compulsory equality. Soviet Russia was reduced to a giant concentration camp. It was called a gulag, in which tomorrow might be worse than today, but it would surely be no better. The United States has traveled that same road with remarkable speed, constantly accelerating the techniques which force our citizens to new levels of personal death and degradation. Under this Marxist system, our citizens have found that the legal system is now something quite apart from the law, that is, the fixed doctrine under which we live. A law is a fixed power. In contrast, the administration of the law today is a fluid power, in flux, and subject to outside influences, mainly the power of money and its committed political influences. When an American citizen comes into court today, he is not faced with the power of or the majority of the law. To his dismay, he finds that his force is no longer present. Instead, he finds that he is facing the power of money and the power of political influence. Enormously, yes. It's who you know or how much you have. It's not about justice. Traditionally, the scales of justice are depleted as awaiting the weight of the evidence. A preponderance of one side or the other will tip them to a just conclusion. Indeed, that is the idea to which we still aspire. Unfortunately, it is rarely found today in our courts. If an attorney finds that his weight of evidence is tipping the scales against his client, he immediately employs one of the miracle techniques of civil procedure to have that his evidence declared inadmissible, to have his opponent's witness impeached or found incompetent, and to mount a counterattack of his own to tip the scales back to the favor of his client. This technique is called practicing law. Like any other skill, it is honed by constant practice, but the skill depends heavily on the practitioner's willingness to employ any suffrage on his client's behalf. It is as though a football game were being played during which the players were allowed to commit any unsportsmanlike or illegal act in order to gain a point, with the umpire, that is the judge, actually cooperating in and officially approving the illegal conduct. In legal parlance, that is, has a name. It is known as professional courtesy, because the judge, like the lawyers, is also a member of the bar. And by the way, he doesn't, well, let's just get to the point, folks. Even the recorder, which is the most powerful person in the court, if you want to make it that clear to you. You know, you have four pieces. You have the judge, you have the defendant, you have the prosecutor, and you have the recorder. The recorder is by far the most important because they're recording all the evidence is being put before all. Chapter 1, called Legal Anarchy. In perusing articles in the nation's press concerning the present practice of law, one can only ask whether the lunatics have finally taken over the asylum. Consider the following. A mother is ordered confined to jail for many months by a judge because she refuses to obey a court order from a judge who demands that she turn over her infant daughter to a divorced father. The mother refuses because she states that the father has sexually abused the child, a statement reinforced by medical evidence. After 27 months of confinement, she's still in prison, but has never faced a jury or been convicted or sentenced for any offense. Another mother in the state of California is sent to jail because she refuses to turn over her 15-year-old son to her husband, who is a homosexual and his lover. A judge in Boston appoints himself the superintendent of schools because he disagrees with the manner in which the city schools are being operated. Another judge in Yonkers, New York, fines the city $1 million a day for racism because its inhabitants who have fled in terror from the drugs crazy streets of Manhattan now refuse to turn their neighborhoods over to the very criminal influences from which they had fled. They have been found guilty of the crime called white flight, of seeking a more stable area in which to bring up their children. It's America courts today, white flight is accepted by judges, prima facie evidence of guilt of the crime of racism. Rather than extremes, these stories are to be garnered from the issues of any metropolitan daily newspaper. However, in more mundane court cases which do not merit attention by the press, the ruling presence of what can only be described as madness, perhaps the peculiar delusion and madness of the crowds, provides endless examples of equally horrendous examples of the rape of American justice and its perversion at the hands of the mob. The guillotine is omnipresent in our courts, where a modern Madame Defarges sits kneeling on the front row. Here again, the blade drops, not on the heads of criminals, but on those who have been found guilty of being productive, law-abiding citizens of these United States of America. Consider the following. A plaintiff sues for damages incurred in an automobile accident. After the person at fault has steadfastly refused to pay any payment, the opposing counsel finds an elderly black alcoholic who will support the defendant's claim that the plaintiff was responsible for the accident. However, during his disposition, the alcoholic states that he is unable to identify either the plaintiff or his vehicle. Realizing that they have a credibility problem, the defendant lawyer suddenly have their witness committed to an insane asylum the day before the trial. He has been an inmate on a previous occasion. The plaintiff demands that this witness be produced before the trial can proceed. The judge has no option but to comply. The alcoholic is brought in front the insane asylum under armed guard. His testimony is crucial to the defense, but the jury must now consider its source. Before this farce goes much farther, the judge hastily saves the day for the defendant by declaring a mistrial. At the second trial of this cause, the judge thoughtfully requested the plaintiff to bring his car to the court building so that the jury can examine it and decide who was at fault. The plaintiff welcomes this opportunity to let the members of the jury look at the car. They file out and solemnly inspect the car, noting that its two right front doors have been smashed in with the defendant's front bumper struck it 3 years before. The jury returns to its deliberation and after 8 minutes files back in the courtroom to deliver their verdict that the plaintiff had backed his car into the front bumper of the defendant, smashing in the two doors on the right-hand side. The fact that this feat defies all the laws of physics carries no weight with them. Verdict for the defense. Developments of this type illustrate the theory of morbid resonance. Morbid resonance is a process by which the past becomes present with morphic fields. The rape of justice is an excellent illustration of the process by which the transmission of causal formative influences become evident through space and time. The memory within the morphic fields is cumulative, so that things become increasingly habitual and more susceptible to repetition. This is apparent in much of our legal systems, where the most outrageous testimony and judicial decisions are made to seem reasonable and acceptable. This illustration, the operation of morphic resonance conceived by an evolutionary spirit becomes impressive. Non-material fields of influence extending through space and continuing time because they are localized within the systems which they organize. They turn the cosmos into a growing organism. However, the process of morphic resonance needs not to be devoted entirely to formulated obscenity or unreason. They can just as easily be influenced by reason and human intelligence instead of irrationality. This process was enforced during the creation of the American Republic, when the finest minds among the American pioneers conceived the Constitution as the vehicle which to enshrine their reason. Even among these founders of the Republic, there was no overwhelming optimism that what they had created would be immune from later abuse. Samuel Adams may have expressed the concerns of his peers when he wrote in 1789, "I've always been apprehensive that through the weaknesses of the human mind, often discovered in even the in the wisest and best of men, are the perversions of the interests and the designing it as well as our of a government. Misconstructions would be given to the federal constitution which would disappoint the views and an expectation of an honest among those who acceded to it and hazard the liberty, independence, and happiness of the people. I was particularly afraid that unless great care should be taken to prevent it, the constitutional administration of it would gradually but swiftly and perceptibly run into a consolidated government prevailing and legislated through all these states, not for federal purposes only as it professes, but in all cases whatsoever, such as a government would soon annihilate the sovereignty of the several states so necessary to the support of the confederated commonwealth and sink both in despotism." Adams did not envision the judicial as the vehicle of this deposition, but his colleague, Thomas Jefferson, who was aware of the perils inherent in a central bank system, as well as the consolidated judicial, wrote in 1821, "It has long, however, been my opinion, and I have never shrunk from its expression, that the germ of dissolution of our federal government is in the constitution of the federal judicial, an irresponsible body that is for impeachment is scarcely a scarecrow, working like gravity by night and by day, gaining a little today and a little tomorrow, and advancing in a noiseless step like a thief over the fields of jurisdiction, until all shall be usurped from the states, and the government of all consolidated into one. To this I am opposed, because when all governments, domestic and foreign, in little as in great things, shall be drawn to Washington as the center of all power, it will render powerless the checks provided of one government on the another, and will become venal and oppressive as the government from which we separated. It will be as in Europe, where every man must be either pike or gunnigan, hammer or anvil. If the states look with apathy on the silent descent of their government into the gulf which is to swallow all, we have only to weep over the human character formed uncontrollably by a rod of iron, and the blasphemers of man as incapable of self-government become his true historians. Modern governments rule by a simple formula, by convincing the masses that they are able to exist by the labor of others, in return for the free existence they agree to cooperate in helping the government crush anyone who dares to speak out in favor of our traditional liberties. Frederick Bastiat, the French philosopher, pointed this out when he said, "Government is the great fiction through which everybody endeavors to live at the expense of everybody else." I'll say that again. Government is the great fiction through which everybody endeavors to live at the expense of everybody else. Note the crucial word is endeavors. The subhumans, that is, the gray men, the materials, those who admit they are unqualified to compete in the games of modern life, sink back into the morass from which they emerged, a morass which is various labeled communism or other dictatorships. In the United States, the gray men have found a unique defender, that is, the court system. Although many Americans express concern but little else about the growing crime problems, few of us understand that most crimes are committed in our courts. If a criminal commits a illegal act, this constitutes a crime. However, when he is taken to court, our legal system then becomes an integral part of the criminal process. The crime of which the criminal stands accused is nothing to the crimes which are now committed in the name of a legal system. During the course of an ordinary legal action, whether it be criminal or civil, from 3 to 10 additional crimes are usually committed. These crimes, in most instances, particularly if two attorneys are engaged, one is a plaintiff, one is a defendant, consist of subordination of perjury, suppression of evidence, intimidation, of silencing of the witnesses, conspiring to obstruct justice, and denial of the rights of the injured party. Because of the citizens committed against them by the legal system, the American people have been for many years engaged in a desperate war, a war to the death. Their mere survival in this war is amazing and almost unbelievable historical event because most of us have no inklings that we are in the midst of a great war. We believe that the war is situated where two countries formally engage each other in battle. In fact, during the past 5,000 years of recorded history, most wars have been internal or civil wars, that is. Very few of them are wars fought against the external enemy. Civil wars obscure the issues at stake, but the result of the same, the survival of the fittest, is still a war of the fit against the unfit, even though the unfit manages to survive by creating alliances, by keeping the issues in the dark, and by dividing and conquering their historical foes. Although the results of this great civil war may result in a temporary advantage for one side or the other, the issue remains unresolved until one side has succeeded in ending the conflict by totally exterminating the opponent. The unfit are resolved that they will be the victors and that the fit will disappear from the pages of history. The fit rarely have a clue as to what is at stake, that is, their very survival, and in most cases, they massacre each other at the clever instigation of the unfit. A further amazing aspect of this impasse is the fact that once the fit do disappear, if indeed they are exterminated, the unfit themselves, unable to exist without their parasitical dependency upon the fit, will also disappear from history. I'll say that again, folks, because it's true. A further amazing aspect of this impasse is the fact that once the fit do disappear, if indeed they are exterminated, the unfit themselves, unable to exist without the parasitical dependence upon the fit, will also disappear from history. Humanity is at a brief happenstance of history will be forgotten. This paradox is explained by the ample evidence of the psychological aspect of the unfit, that they are perpetually mired in their self-hatred, and that their goal of their earthly existence is to end in their destruction. If this is their goal, one may ask, why don't they go ahead and end it? They cannot do so until they have fulfilled what they see as their historical mission to exterminate the fit everywhere on earth before they go down to their own long-sought self-destruction. This dilemma is rooted in the hatred, misery, greed, envy, which characterize the existence of the unfit upon the earth, from which they can never escape, despite American Reagan's fact of improvement of civilization. Rather than face this Rather than face this stark dilemma, most of the unfit prefer to ignore it, turn their attention to some ethereal excuse for not facing reality. It is another paradox that the fit, so able to compete and to excel in any field of life, have but one condition which continues to place their very existence in peril: their refusal to face reality. From birth, they are brainwashed to deny their fitness and to cast about for some area of weakness which will enable them to believe that they really belong with the unfit. It is this brainwashing which enables the unfit to constantly recruit able allies from the fit. Although the educated and the religious systems are constantly maintained and informed to achieve this objective, it is the legal system which remains the final arbiter of the unfit in their war against the fit. The present writer has appeared in American courts for some 40 years, arguing his cause in every court except the Supreme Court of the United States. I have ignored the Supreme Court because it is geared to handle only the pleading of special interests. The individual has no chance to appear before this court. It is a waste of time and money for an individual to prepare and submit a brief to the Supreme Court if he can enlist the support of one of the special interests, who see in his plight some opportunity to advance their own cause. He has a chance, albeit a slim one. During these 40 years of court appearances, a record which exceeds that of most practicing attorneys, this writer has sent elderly judges turn off their hearing aids and sit dreaming of their mistresses while apparently following with intense interest the droning protestations of attorneys and their paid witnesses. Many of us would be alarmed, thinking that if the judges are not listening to the testimony, justice is not being served. In fact, this creates no problem. In most litigation, that is, the case has been described long before the trial actually begins. I'll say that again. The case has been decided long before the trial actually begins. This charade is necessary in order for the attorneys to collect their enormous fees and to convince the ignorant litigants that they have indeed had their day in court. It is difficult to be critical of the judges for not bothering to listen to days and months of testimony and litigation because experts believe that up to 90% of all evidence given in American courts is perjury. The judges may have other impairments which interfere with the proper absorption of vast amounts of manufactured and coached testimony. This writer has appeared before judges who are widely known for their court-a-day habit, a necessary preparation for sitting long hours on the bench. Although most of us might be affected by such daily consumption of the best Southern bourbon, here again there is no real effect upon the judge's rendering a decision, as this has been decided before he took his first drink of the day. Nor is there any question of his impartiality. His verdict usually favors a merchant or a professional man over a complaining customer. There is also no real abridgment of the citizen's access to justice. He does have access to justice, but it is his misfortune that he is totally in the dark as to what kind of justice is available. He has been brainwashed to believe in the impartiality of the law, the application of constitutional principles in our courts, and the absolute integrity of our legal system. At no time is he ever advised of his omnipresent counsel that the constitutional law in which he retains, such as the childlike belief touching in a very innocence, has long since been replaced by the law merchant. That is the law of commerce. The law of commerce, not the law of the land, folks. That changed in 1666. This will be explained in greater detail in a later chapter, but for the moment, let us suppose that the citizen comes back with, well, what's wrong with the law of commerce? It's also a vehicle of integrity, is it not? Doesn't it maintain principles of equality and fair play and honest dealing? Certain aspects of the law of merchants are acceptable. The merchant asks a price and the buyer pays it. There's a warranty on the goods. Debts should be paid and so on. However, there are diminishing ramifications to the law merchant. First, it's always international, although it may be applied nationally. Second, it is recognized no national boundaries or any national obligation. The United Nations, a law merchant entity, has made this clear. For instance, under the United Nations Treaty, the crime of treason against an individual cannot be successfully prosecuted. Did you hear that? Alger Hiss had to be prosecuted for the crime of perjury rather than the crime of treason because it was protected by his acceptance of the United Nations Treaty, which he himself has written. Alger Hiss was one of the co-writers of the United Nations documentation, that is the treaty. Most people don't know that. He was convinced of lying about his thefts of government documents because he could not be convinced of turning them over to the communists. Subsequently, espionage cases in the United States have been prosecuted by the same subterfuge with varying results. Many of the convictions have been attained by relying upon military regulations and their violations. Nevertheless, no American judge is willing to make the pronouncement in open court that we can no longer prosecute the crimes of treason, although this is generally acknowledged throughout our judicial structure. Judges and lawyers are always aware that they are proceeding according to the principles of the law merchant. Litigants are never informed of this crucial fact. Citizens who confidently cite their constitutional rights in court are amazed to find that the judge becomes furious and threatens them with severe punishment if constitutional principles are brought up again. This is our hidden code of justice. Is it not a secret code? Because it is no secret that our courts function on the principles of the law merchant. However, it is concealed from the citizen. Hence, it is a hidden code. When the citizen objects that his constitutional rights are being violated by his foreign procedure, he is clearly informed that you just don't understand how we do things here. The law merchant principles guide the outrages committed by agents of the Internal Revenue Service against American citizens. Americans know that they are guaranteed the right of trial by jury. I cite the 7th Amendment of the Constitution in support of that guarantee. However, the law merchant recognizes no right of trial by jury, nor does he recognize any rights of individuals. There are no rights. There are only adherence to the principles of contract between the parties. This is what people forget. It's all changed in the early 1900s, little by little. Internal Revenue Service would be violating its own principles for the principles of a law merchant to allow trial by jury. For this reason, the tax court does not allow jury trial. The sitting judge is the only person who can render a decision. That's right. There is no trial. There's no jury trial. Another vexing aspect of the internal revenue operations are the continual demands that personal records and papers be produced for their inspection. They cannot know how much of your property to seize until they have made an inventory of it. This IRS custom was drafted by Lenin in his crucial program called the Threatened Catastrophe. In 1917, he laid down the dictum that concealing income would result in the confiscation of assets. Not only did this program ensure his success in setting up the communist dictatorship in Russia, it also became a guiding principle of our Internal Revenue Service. The actual basis of the IRS operations is the communist principle that ownership of private property by an individual is a crime. There's no individual rights, folks, in communism. There aren't. There's human rights, but not individual rights. Big difference. And that's what the human rights, that's what the UN doesn't give you any individual rights. It's all to do with human rights. As individuals who own private property or assets of any kind, cash, bonds, etc., not only is it committing a crime against the communist state by owning says property, he commits as even more serious crime by not making a Jesuit confession that is admitting that he owns said property, which he has concealed, and that he thereby loses his rights to it. It is confiscated by the state. In essence, most judgments by the IRS agents consist of the confiscation of all assets of the accused, not merely the tax owed, but all other assets as well, in penalties, interest, fees, and other assessments. Then Nikolai Lenin has established his dictatorship over the citizens of the United States. American citizens are especially relieved of any obligations to turn over their personal records to government agents, according to our Constitution. However, the compulsory maintenance of records and the compulsory procedure producing of them is in a controversy, the central feature of the law merchant. Without the keeping of the adequate records, recording transactions and payments, commercial life would be very difficult. Therefore, the law merchant compels the keeping and producing of records, a command which is now mandatory throughout our legal system, not only in tax controversies, but in all litigation, despite the fact that the constitutional law states they said records are the inviolable personal property of the individual. However, the law merchant overrides this protection by defining as a merchant anyone who engages in any commerce transaction, whether as a buyer or as a seller. You hear me now, this is just important key. Thus, every citizen engaging in commercial transactions on a daily basis is classified under our present legal system as a merchant, and thus subject to the precepts of the law merchant. Part of that, folks, is to do with, I don't know if Eustace Mullins knew this, but your all caps name is that you're actually working as a corporation. And the lower caps is not. You've been fooled. Once the law merchant has become the dominating factor in our legal system just after the Civil War, this is where all things changed. It was a real revolution, really, folks. Lawyers began to demand the production of personal papers and documents. However, this does not become academic until after the Second World War, when individual nations which had attempted to establish national boundaries for the commercial law and had been identified as fascist nations because of that precept had gone down in utter defeat, and the International Command of Law Merchant had become the law of all nations. Court orders are routinely issued by judges for the production of documents, ignoring all constitutional protection against protection against such orders. These orders also become the instrument for destroying an opponent, because the order to produce documents can run into millions of dollars in costs. Such costs are always ignored by a judge because justice must be served no matter what the cost to the parties. This meant that litigation, which has once been the trial of issues of fact, that is, the conflicting stories of the opposing litigants, now becomes a process of discovery, meaning that a race was on to discover which party would run out of money first and then go into the fall. The present writer has endured many such assaults upon his personal rights. He was stripped of all of the earnings from his historical works, the first history of the Federal Reserve System, when a conniving philanthropist who had guaranteed him all proceeds from the sales of the book embezzled all the income from sales. With no other recourse, this writer was forced to sue him. He was then served with a federal court order by the philanthropist's attorneys to produce all of his income tax returns, expense disbursement, and his other financial data from the previous 35 years, although he had been involved with the philanthropist for only 2 years. Being unable to comply with the federal court order, this writer was then informed he could either go to jail for an indeterminate period, possibly life, since the records could not be produced at any time in the future, or he could sign a quit claim, which he did. The embezzler gave all of the proceeds from the book, aided and abetted not only by the federal judge, but by the precepts of the law merchant. Most Americans being informed of this amazing outcome would say, that's impossible. They can't do that. Of course they can't do that under constitutional law. However, such a court order is routine under the law merchant. At the time of this imbroglio, this writer has seen reference to the law merchant, but naively supposed that it referred to the Uniform Commercial Code. I strove into court prepared to defend my complaint on constitutional principles. Instead, I was quickly ground down by the wheels of our legal juggernaut, the law merchant. At no time did I was informed that our modern-day Benedict Arnolds had turned the court, our West Point fortress of our rights, over to the English foe, or that I was now standing on the property of the Bank of England. However, in future trials, I would be prepared. I will begin by requesting the court to identify each legal procedure used in the trial as to whether it is authorized by the Constitution, citing the Predicate Article, on whether it is procedure or the law merchant against identified by the Predicate Code. The judge has but one defense: to cite me for a contempt of court each time I raise the question. Otherwise, he will have to answer my requests. So that's chapter 1. Let's see what the time says here, folks. It's kind of interesting to hear this. So let's see. I want to look at this because I want to take a little break here. So let's take a break here, chapter 1. Again, he's come to the realization, and you can see this, and I've looked in some of this stuff. I don't know all of it, but I can see that he's realized simply is that he thinks he's going to argue with the Constitution, and he realizes that's punk. There's no way. So he's actually under the law of merchants. And I would suggest a good movie to see is a movie called The Merchants of Venice. This is based upon William Shakespeare, and it was recently done, probably about 15 years ago. It's a good movie. It tells you what's really going on. Now, it's not always to do with the court system, but the last part of it is about the court system, and it's interesting. It's just a good movie to watch to see what's going on. So I'd highly recommend that. The Merchant of Venice is what I think it is called, and you can watch it on. I think it's on YouTube. I don't think you have to pay anything for it to watch it. So I'm going to close out this first chapter here with what I call the book here called The Rape of Justice by Eustace Mullins. And thank you for being here. And hopefully, if you have any questions, I'll try to answer them. But this is really important for people to understand. Many people go into court and they think this is based upon the Constitution. No, that's all changed, folks. A lot of this all changed under, well, a lot of the charges started changing under Woodrow Wilson, but main person would be Franklin Delano Roosevelt, who's involved, who actually tried to stack the court, in his opinion, for his way of getting away what he wanted to get. But to tell you what type of person it is, and everybody puts this guy on a pedestal, and the guy is a I won't go into all that. But anyway, thank you for being here, and we'll probably look at this book either later tonight or maybe tomorrow. It's getting late here, about 9:30. So thank you for being here. And again, this is again, like I said, I recommend you this movie. I watched it probably 4 or 5 months ago. I would say the best thing to do is watch it and see what happens. It's interesting what takes place. And it's brilliant by William Shakespeare, too. All right. Take care. Thank you for being here. You take care.